Hi, this is Rahul Reddy from REDDY NEUMANN PC. Every Tuesday we give live presentation for immigration news. Emily, what do you have today?
Thanks for joining us today. We're going to be talking about the STEM extension, specifically for F1 students, how to comply with it, what are the requirements, how to make sure that you're maintaining your F1 status. We also want to talk about coming elections and how is that going to impact business immigration for employment-based, as well as the upcoming H1B filings. I mean, it's November, we're practically at the end of the year. January is when we start preparing H1B filings for next year's quota, and we have a brand new system this year. What are our plans for that? And 221G, that is a common issue that comes up when people are going for H1B stamping or any type of stamping at the consulate for their visa applications. So what happens during a 221G and what are the options?
Emily, on the extension, STEM extension, you have been to California and you've been a speaker for with the DSOs. With regards to the STEM extension, where the people who are STEM graduates, after their 12 months, they can extend their OPT for the next 24 months. Is it automatic? Do the people have to comply? What are the complexities that arise in those things?
Right, so for the STEM extension, obviously it's only for those that have the STEM degree. You have to file the application, the I-765, before your current OPT expires. So that means you want to start the process a little early, make sure you get the I-20 in plenty of time. You have to be working for an employer that uses E-Verify. You have to be working in a field that's directly related to your field of study, and your employer has to agree to pay commensurate wages and provide commensurate benefits to what they would normally provide for other workers in that same type of position. So all of that is kind of documented through the I-983 training plan, where you'll list out the employer information, your supervisor information, and your worksite information, what your training goals are, how you're going to comply with this training requirement. All of that is filled out by you and your employer, and that I-983 form is going to be reviewed by your school, and if the school approves that it meets all of the requirements, they will then issue the I-20 so that you can then file your I-765 for the STEM extension.
Now, as an immigration lawyer, Emily, that we have faced the difficulties when the people are working at a different location than that of the 983. Of course, we had a situation where 1.5 years ago, that we had a situation where the USCIS or ICE, USCIS website said that you cannot work at the third-party site. Then, of course, our litigation director, Jonathan Watson, sued the USCIS, and then they got to the direction where Jonathan Watson is our litigation director in our office, and then he sued the USCIS as a lawyer, and then he got the things saying that no, they can work at third-party site. After the court, we filed with the court, and before the court decision came in, the USCIS changed the website, and then we have to withdraw the litigation on that. And then it says that you can work at third-party site. Now, we have seen some people who have not listed their third-party site that got their status denied when they filed the H1B. And those people who have actually are working at third-party site, they don't have enough documentation. And then when the company did not provide enough documentation, they got their H1B denied, status denied because of they not complying it. Are there anything else that you found out in your meeting in the California?
Yeah, so the school is required to review that I-983 training plan, and so it's very important that the actual employment information be filled out accurately. So in order to use third-party placement or a staffing agency when you're on that STEM extension, your actual employer, who's the one who is sponsoring or the one who's paying you, has to have a bona fide employer-employee relationship with you, and it has to be the one that's actually supervising you when you're at that third-party site and is actually providing you with the training opportunity. So there has to be some sort of documentation that can establish that that bona fide employer-employee relationship exists, that the supervision exists, and that the training plan is being complied with. And those that don't have that documentation, or it's not properly documented in the 983, where we found that people are listing on the 983 their employer location, the company that's paying them, as the actual training location, which is not accurate, they're the ones getting into trouble. Whereas if you list your employer information and the actual worksite information, then explain how the training is happening, how the supervision is happening remotely, that should qualify as long as the proper employer-employee relationship exists.
I mean, surprisingly, that the generation has moved into too much technology. People can operate remotely, and we have seen satellites operating remotely. We have seen drones operating separately, remotely. We have seen military operating remotely, and they're using drones to kill their opponents. I mean, of course, the employers can operate their employees remotely, and that's what the whole challenge was. But now, the employer and employee need to have documentation in this particular 983 that the reason why they are given a STEM extension is that they need to have more training. Is the employer giving them more training? And if so, what are the reasons and how they are giving the training? And there are some difficulties that we have seen practically. One employer has signed that I personally supervise 280 employees, and they found out that they denied all those 280 H1Bs that have been filed. So be careful on those things, that how can you supervise personally are those 280 people. And then any things that you found out in the DSO's meeting, the university meeting that you went to?
Yeah, I mean, we've seen some situations where a notation has been listed on the I-20 form explaining that I've reviewed this I-983 and kind of warned the the student or the employee that this is a third-party placement and could be subject to some issues. So we are seeing that. We also are seeing some issues where students have in the past had their CVIS record terminated and had it kind of reopened or reinitiated, and were traveling and had some issues at the port of entry when they were traveling because of that prior termination. So definitely, I would say discuss with an attorney if you're in that situation where you've had the prior termination of your CVIS record and need to travel, and as well as if you have that kind of notation on your I-20, it may create issues for you later when you're filing an H1B, for example.
My recommendation is to comply with the audit requirement that the employer has to evaluate the people. So never try to ignore those things. Never try to ignore the things that you need to inform the DSO. If you change from one location to another location, if your EAD is already approved, you don't have to go to USCIS, but make sure that your 983 is updated and you get the endorsement for the DSO. Emily, on the election issue, oh yeah, this administration, that administration, things are going to get better or worse. What is your opinion on it?
Well, I think that, with the Trump administration, we've certainly seen that, yes, the Trump administration claims that legal immigration, he wants people to come here legally, but at the same time is doing everything he can to limit legal immigration, make things as difficult as possible, expand processing times, and increase fees. Last week, we saw the proposal for the upcoming fees for the I-129, I-140, I-485. All of the fees are going to be increased. Premium processing fee is going to be increased from December.
Already, yeah.
The premium processing timeline, they're proposing to change it from calendar days to business days. So that's going to take longer. So I don't see anything good on the radar for employment-based immigration from.
So now the question is that will the administration change? Will it make any difference?
Well, yeah, that's a great question. I think that if we, see a Democrat in office, they tend to be more immigrant friendly. Whether that's immigrant friendly for employment based is a little bit difficult because I feel like, from what I see, the Democrats tend to be more favorable to undocumented immigrants and trying to solve those problems and kind of leaving the legal skilled immigrants in the dust. I don't know your thoughts on that.
I may disagree with Emily on it. I've been an immigration lawyer longer than her, much longer than her, maybe 7, 8 years longer than her. I've been in Clinton administration. I've been in Bush administration as an immigration lawyer. I've been in Obama administration, and then I've been in Trump administration. Things only get harder. You just need to be prepared for it. At this point of time, fight for the 386 bill. That's the best thing that you can do. It's going to get harder. And it's, we are here, and as an immigrant, it's not your duty to get into the politics. You just need to do what you have to do it. Don't get into the details of the politics. It's only going to get harder, guys. I've been in Clinton administration, then it moved to Bush. Bush was a favorite of the immigration, but still he didn't do it. Then we thought that, okay, Obama is going to do much better, but he didn't. I mean, things have changed at the Obama administration. Newfield memo came in 2010, and then we got this Trump administration. So don't assume that. Take the things in your hand and try to fight for the Senate 386 bill. Things are not going to get any easier than what they are. Even whatever that comes, be prepared for it.
All right, so we also have, the new H1B registration or pre-registration for the lottery next year. We had the final rule published that says they're going to create a $10 filing fee for the pre-registration process. Once everyone registers, they'll run the lottery based on that. And then there'll be 2 separate filing windows for everyone that was selected, so you'll have time to prepare your petitions and file. So what do you think the chances are of this pre-registration actually working out? And what do you think the impact is overall on the number of filings we might see?
One thing is that I was disappointed in the pre-registration was that it only requires the name of the person, the passport number, the date of birth of that person. It may go to too much fraud. And the way this administration is working is that to lure the people into fraud and then go after them, instead of preventing it from the beginning. I mean, it's good if somebody is doing a small theft, you prevent that guy so that that guy never gets raised. Here, they want to lure into the people. That's the fear that I have on this one. Overall, I still think so that the number of applicants are going to go up because the economy is very good. Hopefully, that they're going to come up with a very strict fraudulent things that if you are registering for one person at 3 different places, if you don't file, they're going to have a criminal action on it. That's what I would think. But the number of people that are going to file on the lottery is going to go up very significantly. $10 is a little bit lenient. I would rather would have to have end client information where they are going to work at and a lot of more details, but they didn't ask in the registration process. That's surprising. Are they trying to lure the people into fraud? Are they trying to prevent the fraud? If they want to prevent the fraud, they should have gone through a little bit more details rather than having. Now you're having $10 to put it on. A lot of people will just say, okay, some fraudulent companies are there that are going to put it. My advice to people is that if you're not working for that company and you want to file an H1B and you are going to have them file for $10, don't do it. And the main question that comes is that a genuine job if you're not working for it? Well, a lot of people will take an oath saying that it's a genuine job. I would recommend that you contact a company, you contact a lawyer to get it verified. If you are working for, let's say, for ABC Consulting Inc. with a X company and client, and they are filing for the lottery, I have no problem in you registering it. But if you're not working for that company and they are filing it, even though they are not charging the money. They'll say that they'll charge you the money later on or what. It's all fraud. Don't go there. They are going to be arrested and and you will be in trouble too. So this is a major thing that I have a problem. And I belong to the community that a lot of H1Bs are filed. I know how the things come out. When they get married, when they get the H1B, when they get the green card, they publish in the YouTube, they publish in the Facebook, all those things. But something hits on them, they consult us. And it's every day that happens. If you're not working for that company and they are going to file in the lottery system, be careful, don't go with them. Emily, you have any different advice on that?
Yeah, I would definitely agree with that. I think that there has to be some sort of vetting of the company as well as the H-1B applicant prior to the actual lottery happening. So, we are talking amongst our team about discussing with employers how to review the job offer, the SOC code, the wage level.
Is it required for you to file the lottery?
That's the thing, is it's not required for the registration. So, there's no looking at the merits of a case at all when you're registering, which is going to vastly increase the number of people that are registered, unfortunately, which makes it difficult for those genuine applicants that are filing. But, we're guiding.
I am also concerned of the duplicate filings, Emily. A master's guy who's been there for a year, he missed the lottery. He will go to 5 different employers and register with 5 different employers. And then what will happen? And the chances of him with a genuine employer will decrease. The chances with a fake employer is going to increase. And that's going to be trouble for everybody.
Yeah, I definitely think, obviously, you feel like you're helping your chances by filing with multiple different employers. We've been talking about this for years. Don't do these duplicate filings, only file with a genuine employer where you have a genuine job opportunity. And now the possibilities of people to file with multiple employers has skyrocketed because it's such an easy process. All they have to do is submit your basic information and pay $10 and you're in the lottery. So unfortunately, I think that's going to be a byproduct of this registration process. Now, the interesting thing is we still don't know for sure that the registration process is going to be in place. So we have a final rule, we have the $10 fee now, we're in mid-November, we still don't know for sure what this lottery is going to look like. We have not seen any announcements of when you can register, where to go to register, what the requirements are, and it's mid-November. Companies are making their hiring decisions now and should be planning on filing in January, even though they're not filing until April, but they plan this process out several months in advance. So the fact that we don't have any information yet, we have our, USCIS director saying, we think we're going to be implementing this. We have a pretty good chance. We think it's going to be, we have high hopes. There's just no specifics about this process, which makes it really difficult for employers, a lot of uncertainty for employees. It's going to be a bit of a mess this year, unfortunately.
Even though this regulation having a pre-lottery system, we appreciate it because in general it's good rather than filing the entire application. But we would have rather preferred to have a fraud prevention thing for this one a little bit more rather than trying to go attack them afterwards. And then we would have more surety than what Emily has said, that we don't even know if it's going to work out or not. These are the 2 objections, and Emily has pointed out in her blog at Immigration Girl that these are the 2 objections that she had when these regulations were passed. After this administration came in, this is the only regulation that ever passed on the H1B. There's no other regulation. We appreciate this one, but they should have been a fraud prevention and a certainty of those things. Emily, on regards to the 221G, that those people who go and apply for the visa, and then we have seen a lot of queries coming out. Any prevention things that can be done in?
Yeah, so a 221G basically means that you've temporarily been refused the visa, and it could be for a number of reasons. It could be because you've missed submitting documents. It could be because they have to go through a security advisory opinion because of some sensitive technology that's in your background, or it could be because of fraud prevention purposes. It's just a general, this administrative processing is a general term for things that have to be accomplished before they can actually issue the visa. But it is technically a refusal of the visa right now that they might overturn later once they go through this process. So we find a lot of times that when people are going for their visa interviews, the interview itself is only 2 minutes long, but people are just not prepared. I think in the past it was a relatively straightforward process, pretty simple. You show up with your approval notice, you fill out the form, you're going to get the visa. It's not like that anymore. We are in the age of extreme vetting. So just always think of extreme vetting in the back of your mind whenever you're filling out the DS-160 application form, when you're preparing, when you're going for your visa interview. Make sure everything is consistent. Now, obviously, it has to also be truthful, but make sure that you're consistent with what information was given in the H1B petition or the L1 petition. Make sure that you are not misrepresenting your past experience or your employment history or school history. I think that's kind of a big issue that we're seeing right now, is just differing dates of employment, differing job titles compared to what's in the immigration record versus what you're listing on your DS-160 application. The biggest thing I can tell you is review what was filed on your behalf. You'd be shocked to see how many people just don't even look at what was submitted on their behalf. And so when they're coming in, they're explaining things in their terms, which is completely different from what the employer submitted in their petition. And those inconsistencies create a shadow of a doubt. And once there's a shadow of a doubt, it's going to spread and taint everything you say from that point forward. So assuming that what was mentioned in the petition is accurate, you should review that and make sure that you're answering the questions consistent with what was given in the petition.
Emily, as you said, that they have only 2 minutes. Actually, it's only 30 to 60 seconds that I know of. I've gone through my own thing. It was only 30 to 60 seconds, which is less than that. So it is where the misconception from the people come in. The consulate only does 60 seconds, according to me, and according to Emily, it's 2 minutes. Now, the question that pops up to you is that, what do they know in those 2 minutes? No. They know a lot. Before they come and speak with you, they review the file. Then you comes a question that, whoa, my file is 150 pages. Believe me, guys, we get to consultations. Emily and I get to consultation. They send all the papers to us. It's 200 and 300 pages. Guess what? We go to the point so quickly because we are so experienced. We are so experienced because I deal with 4 or 5 consultations a day, and our team, and we have discussions we go through thoroughly. Well, when it comes to the consulate, they don't go to 4 or 5, they go to 40 or 50. They know how to review the whole file. They get to the details so quick and so easily. They know what they are. When they are asking a question, they most probably know what the answer is going to be. If they are telling you where are you going to work, you give them any answer. They already know the answer. If that answer doesn't fit to that, you are gone. Why doesn't that answer fit to it? They are reading the petition. Oh, do they have time to read the petition of 200, 300 pages? Well, believe me, we can read it in 3 to 5 minutes. And most probably, these consular officers can read it much faster than we are. We go through those things, we go to the point very quickly. And they do give, and that's a misconception. But when you are the person who is going to go for the interview, the number one thing that I recommend is read the employer letter and read the DS-160 form. Oops, I am married to this lady. What is it? What does your Facebook says? What does everything says? What does your LinkedIn says as compared to your H1B petition? Be careful. If you do the mistake, you're gone. Don't assume that their 2 minutes, they are not reviewing it. No, you should review it for 2 to 3 hours before you go in there.
Yeah, they know exactly what they're looking for. It's just like you said, like if we are doing a consultation and we're sent a 15-page request for evidence to discuss during this consultation, now I can review that 15-page request for evidence in about 30 seconds and know exactly what the issues are and what the problems are going to be. Consular officer is just as knowledgeable. They know what the problems are, they know what the issues are, and they will ask questions, and they're not going to come straight out and ask you a direct question. They're always going to ask kind of a roundabout way to get you to, I guess, lull you into a sense of security when you're answering that question. And so you just have to be prepared for it. Spend the time. Don't assume that it's a given that you're going to get the visa. It's not the same process that it was just a year ago, 2 years ago. It's definitely different.
Emily, one tough question that came out with that, the H4 EAD litigation that is going on. I mean, there are people who are announcing that, oh, H4 EAD litigation is gone, H4 EAD is going to be forever. What's your comment on that?
Yeah, I feel like a lot of people feel like whatever happened in the court last week was a major victory for H4 EAD holders, and it really wasn't. It was the exact opposite of that. It was a victory for the plaintiffs in the case, the Save Jobs workers, because, so let me give you kind of a quick overview of what's happened so far. As soon as the H4 EAD regulation came into play back in 2016, a lawsuit was filed saying that the Trump, at the time, the Obama administration did not have the authority to grant employment authorization to H4 holders. That's something only Congress can do. That's the basis of this litigation. Now, the lower court actually dismissed the lawsuit because they said that the workers the U.S. workers who brought the lawsuit against the Obama administration did not prove that they could actually be harmed by the regulation. So that was it, end of story, lawsuit over. Then the workers appealed that decision to the appeals court. That's where it's been set since then. They appealed it, and then after the Obama administration left, the Trump administration came in. They said, hold off, we don't know what we're doing. Please put this case in abeyance, meaning hold it, until we decide what we're going to do. And then they came back a few months later and said, we think we're going to issue a new regulation that actually rescinds the H4 EAD, so there's no reason to consider this lawsuit because we're going to get rid of it anyways. That's kind of where it's been. The Trump administration was supposed to give updates to the court every so often about what's going on with the regulation. Well, they were giving these updates, but they were so vague and just nothing's been happening. I mean, we've been expecting this regulation for years now, and there's still no proposal. So finally, the U.S. Workers Union got tired of waiting, and so they came back to the court and said, look, clearly they're not going to proceed with this regulation. Let's get on with the lawsuit. And the court agreed. Now we get to the point where arguments are actually had at the appeals level where both sides argue. The U.S. workers are arguing that the Trump administration did not have authority and that they do have standing to bring the lawsuit, meaning they are actually harmed by the H4 EAD. The Trump administration says, no, you're not actually harmed, and by the way, we're getting ready to get rid of it anyway, so let's just let that process play out. Well, finally, we have a decision from the appeals court that says that we agree with the U.S. workers that we think you are being harmed by the H4 EAD. That was the only issue they decided on, is whether there's enough harm for the U.S. workers to actually bring the lawsuit. No one has ever gotten to the merits of the case, which is whether the Obama administration had the authority to create this EAD out of thin air, because only Congress is supposed to be creating immigration laws. So because this court said, we think they're standing, now we're going to send it back to the lower court to actually get to the heart of the matter. That's where the case is right now. I think there's a lot of misinformation out there. Some groups are claiming that this is a victory for H4 EAD holders because now we get to continue the H4 EAD for some time. To me, it's actually a loss because yes, they do get to continue the H4 EAD for some time, but had the appeals court dismissed the appeal on the grounds that there was no standing, that would have been a victory for H4 EAD holders. This was actually a loss for H-4 EAD holders, sending everything back. We start from the beginning. Now we're going to actually get to the heart of the matter. Did the Obama administration have the legal authority to grant EADs to some H-4 holders? That's the main issue of this case. Of course, all of this may go away in the litigation if we finally do get a regulation. So those are that's where we stand right now. It's back to the lower court. Everything could stop in the court if we have a regulation, or the court could ultimately decide. And if the court decides, yes, the Obama administration did have the authority, then at least we have that precedent, which is very important because it also impacts STEM OPT and other presidential executive orders that created different employment authorizations for different
including
people.
the regulations that created. Emily, on your DSO speaking that you did in, how many DSOs were there?
I think there were close to 1,000 DSOs
Oh,
there.
yeah, nice. And let me understand that. On the STEM extension, we have, can there be an ICE visit for complying with the law? Have you heard any ICE visits? Is there any problem with the ICE visit with the STEM extension? What are the things that the people can be prepared with the ICE visits on those things?
Yeah.
On the STEM extension after the 12 months, the 24 months period that I'm speaking
Yeah, so when the new STEM OPT rule was created that made the 24-month STEM extension, it specifically gave the authority to ICE to do site visits to verify that the training plan is being complied with and that the regulations are being complied with. Now that regulation came out in 2015, 2016. We've not really seen any site visits until this year. So finally ICE is getting around to those site visits. So far, I haven't seen anything really scary to be worried about. It's been a lot of kind of advance email notice to the employer saying, we intend to visit on this date. This is the information we're going to want. And they visit on that date and you provide the information and they go on to the next case. So I don't think we've seen any negative impacts from these site visits, but we've also started seeing that ICE, through their SEVP program, has been requesting some copies of the 983 forms to verify compliance as well at different schools. So that seems to be maybe their next level of compliance checks. We haven't seen any negative consequences of this yet. I don't think that the ICE visits are, typically when people think, oh, ICE is knocking on my door, I need to be scared. I don't think it's at that stage yet. They're really just checking for compliance. There's not a lot of teeth to that regulation that say, oh, if we find you're not in compliance, we're going to put you in detention. There's nothing like that. So as long as you're in compliance, I think that it's a relatively safe process to go through and nothing to worry about.
This question comes from YouTube from Vijay. He's asking this question. He's an H1B and his H1B is expiring on December 2nd. He's planning to file a F1B, F1 change of status. Can he stay in the country legally while his change of status is pending? The answer is no, you cannot. If you filed an F1 visa, you need to maintain your status until your F1 is approved. There is an exception of 30 days before the F1 is approved. Nowadays, it's taking about 8 months, 18 months. So I want you to maintain the legal status until your F1 is approved. There are some ways you can do it. You can file an interim B2 extension while your F1 is filed. So it's a very sensitive issue. A lot of people ignore it. We see that a lot of people violating the status on that front. So be careful. Don't do it by yourself. I would recommend to go to an immigration lawyer. Our office doesn't do it, but we still recommend that you go to some other law office to do it, because you cannot stay while F1 is pending if your H1B is expiring. Another question comes from Sam. It's an interesting question. Green card process, is it faster on a L1B compared to the H1B? No, absolutely not. L1B and H1B green card process is the same. Now, if it is a multinational executive, EB1C category, it may be different. But in general, the green card process for L1B and H1B is the same. If it's a multinational executive, most probably that's applicable for L1A. In some very rare cases, it may be applicable for L1B, but not in general though.
Anam from Facebook wants to know if someone doesn't work for the sponsoring company that they receive their green card through, is that going to be a problem in the future? So the short answer is possibly. And of course, as lawyers, that's always our favorite answer is maybe, it depends.
I don't like it. I've been a client of immigration lawyer, so I know.
Gotta give you the whole picture here. So there's nothing technically wrong with that. I mean, when you are sponsored by an employer for the green card, especially if your 485 has been pending for 180 days, you're eligible for AC-21, which allows you to take your whole green card process with you to a different employer as long as the job duties are the same or similar occupational category. But if you have been sponsored by that employer and then never work for that employer, it can call into question what your intention was the whole time. So whenever an employer is sponsoring you and you have filed your 485, you are saying that I intend to work for this company that sponsored me in the position they sponsored me for. And your employer is saying the same thing when they file the I-140 petition or potentially the I-485 Supplement J. Your employer is saying, I intend for this person to be in this position when they get the green card. I'm going to hold this position open for them. So now the best way to prove your intention is to actually follow through with it and actually work for that employer. But if you're saying that I intended to work for this company and the employer is saying I intended for this person to work for me, but you never actually work for that company, yes, it could become an issue, particularly for citizenship. I think when you finally file your N-400, they do look at that employment history and they could call into question whether that was actually a bona fide job opportunity way back at the time you applied for your green card.
Question comes in, is the L1A green card process different than H1B? Most probably the answer is yes. The L1A can fit into EB1C category. The process is maybe much faster in there. Rahul from Facebook has this question that, is birth certificate needed for the green card processing? Yes, it's needed, Rahul. It's needed. But there are a lot of exceptions. I know I come from India. I'm also a lawyer from India. If you don't have birth certificate, there are a lot of alternatives that you can bring in. There's called non-availability certificates. You can get 2 affidavits. You can get your voter ID. You can Aadhaar card. A lot of different categories. We at Reddy Neumann PC will try to write an articles addressing the issue. So Rahul, if you want to go to RN Law Group and you can say, a birth certificate, there is an article that if you don't have the original birth certificate, what are the alternative things that you can do? And not only this particular article, it addresses exactly if you don't have birth certificate, what are all the alternative things. We at Reddy Neumann PC, we get a request from a lot of people that saying that write an article on this front. We do write an article. And anything like going to Mexico or visa revalidation, a lot of different things we write articles. Please subscribe to RN Law Group and also Immigration Girl, which is a blog. She writes any updates. And if anybody wants to have an article on those, on a particular items, you can request it. We write an article on it. We address those things. If it's a common issue, that can be simply addressed. For example, Rahul's thing, I mean, birth certificate. A lot of people don't have birth certificates that are born in India. How do you address it? There is a separate article that we address it. So we try to address it. Thank you, Rahul, for asking that question.
Yeah, so if you have a particular question, you feel like there's not an article addressing it on our website, you can always send an email to info@rnlawgroup.com with what topic you'd like to see, and we'd be happy to post an article on that specific topic for you to give you that education.
And there might be some times that we may not want to write an article. It's a little bit sensitive issue, how the people will articulate the things. Then we would rather want to address it in in the live session, and we do have daily conference call, and then you can have a personal session. But some things like that are very common. I don't have a birth certificate. We would like to address it in an article.
So Srikanth from YouTube wants to know, to be able to get an H-1B transfer for a managerial position at a different company, is it necessary for the beneficiary or the employee to already be in a lead or higher level position at their current employer? So the answer is technically no. I mean, there's no requirement, there's no relation between your current employer position that you're on an H-1B for and the new employer's position. So just because you're at a low-level position at your current company doesn't mean that you can't transfer to a new company for a higher-level position. It's all about whether you actually qualify for that position. So if you meet the qualifications for that job and it's a specialty occupation, you can absolutely file a transfer regardless of what your old position was.
Rakesh from Facebook has this question. L1B blanket extension got denied. Can he apply for a fresh H1B? Yes, you can apply for a H1B. The requirement for a H1B is quite different than that of L1B visa. We have noticed recently that a lot of L1Bs and L1As are getting denied, but you're still eligible, Rakesh, for getting the H1B in the lottery system. Absolutely, that's not an issue. Just because your L1B got denied should not have much impact on the H1B.
Krish from YouTube wants to know if we're expecting any forward movement in the EB1 category for December 2019 for Indian nationals. My answer to that would be most likely no. I don't think that we're going to see anything. January would be the earliest that we can see any kind of movement. That category has definitely got a backlog in it as far as Indian nationals, and it's going to be very slow moving going forward. I don't think it's ever going to be current again, and for it to actually move forward, I don't think it's going to happen in December, maybe January at the earliest.
Emily, that question pops up that there's a discrimination in the Constitution that says that you can't discriminate based on race, national origin, and all those things. And now, Indians and Chinese are getting discriminated on based on that. Is there anything we can do about it?
Yeah, I think the best thing we can do about it is push for S386, the Senate bill, because that's the one thing that actually removes that provision and would allow things to move forward on an equal playing field for everyone. I think that litigation on that topic, when they created this 7% cap, there was no racial animus meant. It was meant for diversity. They had a rational basis for doing that.
Well, there's a diversity visa that's separate than employment-based. This employment-based is actually created for the employment-based. Mm-hmm. So where is the rational being diversity on this employment-based, Emily?
Yeah, I mean, you could definitely make that argument that it is, country of birth should have nothing to do with your merit as an employee and your ability to be sponsored.
So this is called discriminatory on the face and discriminatory on the effect. On the face, there is no discrimination on this employment-based immigration, but the effect is there. Now the question is that, is there an intention? Back in those days, it doesn't look like there was an intention, but there is a discriminatory effect, and that can be challenged in the court. We are considering, REDDY NEUMANN PC is considering, if the Senate 386 bill is not going to be passed in the next 1 month or 2 months, we are considering suing the USCIS, and we are well equipped with it right now. Of course, we need to get into Supreme Court lawyer, which I'm one of the Supreme Court authorized to practice in Supreme Court, but we are going to try to align with some other Supreme Court lawyers to make sure that we can take this forward. But yeah, a country of birth need to be challenged. If the Senate 386 it's not passed, I think so that need to be challenged, Emily.
All right, Uday from YouTube wants to know, his wife has an H4 EAD until 2022, and she's planning on applying for an H1B in April of 2020. If the H1B gets picked, can we do a vacation in Canada in August of 2020 and be eligible for automatic revalidation? So assuming that the H1B petition requested a change of status, not consular processing, and you're planning on traveling while it's still pending before it's approved, when you leave the country, it's going to automatically abandon your change of status portion of the petition. It's going to convert your H-1B to consular processing. That doesn't impact your ability to use automatic revalidation to re-enter on an H-4. So if, for example, you have the H-4 and the EAD that's valid till 2022 based on I-797 approval notice, but your H-4 visa stamp has already expired, you can travel to Canada for less than 30 days if you don't go for stamping and come back in, and it will revalidate your visa as if it's valid on the day you're entering and come back in H-4 status. So the travel really is not an issue unless you are requesting a change of status on the H-1B. That will automatically be abandoned if you are traveling while it's pending.
Emily, I need this your attention on this. Harsh has this question that I know, you've been successful in getting the H-4 EAD's approval out of the 500 cases. There might be only 3 or 4 cases that got stuck out more than 60 days after the litigation has been filed. Now, Harsh has this question, can we do the same thing from H-4 to F-1 change of status?
I don't see why not, because I feel like, the basis of our lawsuit is that Congress said a non-immigrant visa application should only take 30 days. An I-539 change of status request is a non-immigrant visa application. So any change of status from whatever status you're currently in to F-1 should take a maximum of 30 days, yet USCIS is taking 8 months or more. So once it's pending for 30 days, absolutely, I think that you can file litigation for the unreasonable delay and ask the court to require USCIS to adjudicate that in a timely manner.
A couple of things that if your spouse has filed an I-140 thing, I may be hesitant in filing the litigation, Emily. That if the spouse has filed an I-140 got approved, I don't want to file their litigation though. The second thing is that it may be a little bit costlier than what we file for a H-4 EAD litigation, that we file almost like 50 people every other week. That's almost like 5 people every working day that we file. It may be a little bit costlier because we may not club in too many people in getting that. But yeah, it's a good thing. We can, nothing wrong with it. I mean, they're taking too much long time. Instead of spending all those things on B2 extensions, you might be better off going to the litigation process.
Amit from Facebook wants to know, what are the chances of getting a denial on an H-1B extension if you get an RFE while doing premium processing? Well, the fact that it's premium processing has nothing to do with your chances of denial. The fact that it's an extension has nothing to do with your chances of denial. It's all about, does the position that you're being sponsored for qualify as a specialty occupation based on the higher standard that we're seeing now? Do you meet the requirements for that position? And does your employer have enough specialty occupation level work available for the next 3 years or whatever time period they're requesting on the extension? So I can't really answer your question because I know nothing about the job opportunity, what SOC code was selected, which wage level was selected, what your education background is, what your education evaluation says. Those are the things that determine what your chances are in getting an H-1B extension approved. The premium processing has no impact on your ability to get an approval or a denial.
A lot of questions on this backlog of the immigrant visas. One thing that came out from Shakti is that my I-140 is approved for more than 180 days. Can I go back to India and come back in H-1B after 2 years? Yes, you can. You will not be subject to cap. You will be able to retain the priority date if your new employer files it. Absolutely not a problem. The other question that comes up is that, what do you expect of these priority dates moving right now in the backlog? Unless Senate 386 bill passes, unless we are successful in suing the government on the discrimination on that, the priority date backlog is going to be a long period of time. And the people are asking that, is there any statistics where we can look into how many people are pending? We at REDDY NEUMANN PC at rnlawgroup.com in the news section, you can look into it. It's a backlog. I want to search part 108.6. That's the years we said in February of 2018. So when you search in there 108.6, that's the one you search, you get it. That's how many years it's going to take for the people if you're going to file the green card in February of 2018. But then in August of 2018, there is another institution for Cato Institute, which relied on the same kind of thing, but they have a better data. They said that we are wrong by 42 years with regards to how much time it gets to the green card. They said we are wrong by 42 years. They said it's not going to be 108 years, it's going to be 150 years. They have much more funding, they have much more research thing. You can search cato.org, and they have a statistics on how they came with 150 years, and they have a statistics and they have links to those things, and we have too on the links. You can search both of those things. Cato Institution is a good organization. You can search those links, or you can search our links with regards to where the backlog is, how much time it's going to take to cover the backlog.
Sriram and Sai on YouTube have some similar questions. So Sriram wants to know, with the new system for the H1B lottery, can a person apply through multiple companies? Is that legal, assuming that they're all genuine companies? So the restriction on multiple filings is that one employer should not file more than one registration or more than one petition on behalf of the same individual person. And so technically, if you are being...
I have some reservations, Emily, on what you're going to be speaking. Be careful on every word what you speak, because there, even if there is no job, people are going to interpret your word differently.
Mm-hmm. Yeah, for sure. I mean, we're talking about genuine filings here. When people say genuine, I mean you have like a job offer from Google and a job offer from Facebook.
Oh no, I have from A, B company, I have AA company.
Yeah, that's a little bit different. So that's the difficulty here, is the only restriction is the same company filing for the same person more than once. And that's where Sai Krishna's question come in. He says, doesn't USCIS check for the passport number to see if it's a duplicate filing and present it?
They do.
And that's the problem, is they don't when they're actually running the lottery, and that's why people get selected more than once. But in this new system, they are going to be tracking when a particular company files for, say they filed for 20 people registrations, 20 people that don't work for them and they don't have 20 jobs, and then they get 10 selected and they only file one petition. They're going to be tracking that, and they will verify, how many petitions you actually requested, how many registrations you actually received, and if an employer is trying to game the system, that employer is going to get in trouble, and your registration is likely to be questioned, and that may question your ability to actually get the H1B. So all that to say, we don't and we never have recommended filing with more than one employer, especially when it's a consulting firm that claims they have an in-house project for you that doesn't exist. It's a company you don't work for. It's a company that wants you to pay them for the privilege of filing on your behalf. Don't get into any of that. Only a genuine employer is going to sponsor you if you're actually working for them. If you have work authorization right now, the only employer that should be sponsoring you is the one that you're actually working for right now. All these other companies are very likely fraud. They're very likely trying to cheat you out of money, and we just don't recommend it.
My thing is that if you are filing 2 applications, I want you to get certified by a lawyer. It's okay to do it. And there are so many people who paid me the money. As of now, I did not certify it for a single person yet. I did not. And guess what? How much money we made in our office? A lot of money. People who got into trouble because they filed with these agencies that filed for a duplicate when they are not working. So we make more money when you file those fraudulent cases because we prey on those things. Believe me, don't do that. That's a big trouble. I have never certified. all the time. I have this genuine job opportunity. Are you working for them? No, I'm not working. Is there a project for them? Yeah, if it's a Google and then my favorite company, Tesla, I understand that. But if you're telling ABC Inc. and then a BBC Inc., not BBC, let's say LDC Inc., I doubt you very sincerely that it is. There are situations, I didn't certify them, but if it happens to be, their talent is there, they went to Stanford and all those things, and they got opportunity in those things, I said yes. I didn't email them, but I did. But 99.9% of the time, it's fraud. And what happens is that the USCIS does one thing. They approve them without the RFAs. And the reason why they do it, they go to Congress and say, we approved the H1B. They don't tell them they revoke it later on. So many people get their H1B revoked because they file fraudulent applications. There are so many articles on our website, YouTube, and Facebook that tells that don't do that.
But what if I file a transfer to another company?
No, transfer is different, Emily. When you're filing transfer to different companies, when two companies, you are not trying to circumvent the lottery system. You are trying to look into the alternative chances. If I have an employment with two different companies, I want to see which one comes in, especially in the Trump administration, when the I-94, that's different. You're not trying to circumvent the lottery system.
But what if I got my cap case approved because I filed multiple petitions, and then I transfer to a different company so that I don't get caught? What happens?
That's a very good thing. That's what we get more money on that. Because what happens is that you file with company A, that got approved, which we know what the in-house project is. Then you move to company B. Guess what? Company A gets revoked. Even if you're working with my favorite company, Tesla, they're going to revoke that H1B because the first H1B was been counted fraudulently. This happens so many times. Every week, I personally come across 1 to 2 consultations that get these things. And then guess what, Emily? They don't come to Facebook. I can't announce their name. And that's the problem. And if they get a H1B, they go stamping, they bring their prized wife and they put them on the Facebook, but not these kind of things. So please, these are the things, we announce it, we have backing what we are doing, and please believe us on these things. This is going to be, you're going to be in big trouble, and this time I believe the USCIS is trying to trap more people.
All right, 2 questions from Facebook again that are kind of related is, when can you file a transfer? Is it safe to file a transfer when an H1B amendment is pending?
Absolutely safe.
What
If
about,
I-94 has not expired, it's absolutely safe. Even if your amendment gets denied, you will not have any impact on the transfer.
And Natansh wants to know, what if my extension is pending? Is it safe to file a transfer?
Did his I-94 expired or did not? That's the main question. If the I-94 did not expire, your extension is pending, you file a transfer, you are good to go. But if the I-94 expired though, we call the extension application as a bridge application. So if the I-94 expired in September, your extension is pending, and you filed an extension while the extension is pending, if the bridge application is going to be broken, your transfer of the application will be denied, or it will be approved without the I-94.
All right, we have another good question. I know we're getting close to our time frame, but great question from Ravi on YouTube. Why is it the H4 needs a biometric appointment and not the H1?
Well, it's a logical question, guys. I mean, you guys are engineers. You guys ask logical questions. Unfortunately, we are lawyers. And really, the first thing that we tell them in the law school and the law clerks, young lawyers that come into is that keep the logic out of the law office before you come in. I don't know any other reason.
Yeah, there's absolutely no logical reason for it.
No logical reason. Why not H1Bs? Why? And guess what? I hope this will be deleted. Don't give an idea to Trump administration that H1 reads it, and that's going to delay the whole process. No logical reason, absolutely no logical reason, no legal reasons we can explain.
All right, I think that's about it for today. So thank you for joining us. If we didn't get to your question, you can always join one of our daily conference calls. Those are free. You can go to rnlawgroup.com to get the dial-in information and the schedule for that. And please feel free to subscribe to our website for our daily updates whenever we write an article. We try to focus those on employment-based immigration. So feel free to subscribe there. And you can also subscribe at immigrationgirl.com.
Thank you guys for tuning in.